Land is a finite resource, and it has participated in the development of different societies. For each and every society to develop and to grow, it depends on land for its food, for its or activity. In this development, we have come to set statutes and laws that will govern land as we know it. Hello and welcome to this episode as we discuss laws that give land value and laws that restrict the same land. I am Daniel Wainaina, a surveyor and a land expert. I'll be exploring different laws and how they affect our relationship to land. As I have said, that different laws have been put in place through the development of land. These laws are important because they set the key elements in the registration of land, in the disposition of land. Like you are developing a certain area, how do you develop that land and you be within the statute set in place. Such laws that affect land directly are laws of registration. And when we mean laws of registration, they are laws that define how we register property or register land in the land registries or in the different registries that we have in the country. First and foremost, before you register any land, you have to get an outlook of what that land looks like. An entire piece of land that is covered or is shared by a community can have thousands of acres or hectares, and you want to register this piece of land. What you do is that you get to map the entire land or the entire community land in that case. Then you go through a process we call adjudication. And in the adjudication, you will sit with the community, get to understand how they relate, who owns what are the extensions of the boundaries, or where to where do their boundary extend to. When you get to understand that, because these community members are stakeholders in the process of registration, you will put in place a process to map those boundaries as you are being shown by the community members, mostly elders. They'll tell you that the land of a certain family starts from here and it ends to a certain location. And mostly they are defined by natural elements. They can be bushes or they can be radstones or even levers for boundary or edge of the land or edge of that family. In this process of adjudication, what you are doing is like subdividing the entire community land into different plots or different sub-parcels. You had a larger parcel, you subdivide it into smaller parcels. And now what you will get as the end result, you will get a map. Then inside that map, you will include or amend the new subdivisions that you have done or carried out, or the new adjudications you have done on the ground. From there on, these new adjudications will be given specific and unique land numbers. We call them parcel numbers in such a case that the parcel numbers start from, we can start with the higher level like the county, then the location or sub-location, then the number of the parcel. Given that each parcel has been given a unique identifier, then you can proceed to note that a certain parcel with a certain number is zoned to a certain person. In order for you to do any registration, you need unique identifiers, and we have already gotten the unique identifiers, the parcel numbers and the identifications of these people or their names and the ID numbers. Then you will correlate the parcel number to the owner who owns this parcel number 1, so and so, who owns parcel number 2, so and so. Then all that record will be put in a register. The new opened register will note the parcels, their area, and the person in charge or the owner of that parcel. Since you have recorded all that proof that a certain parcel is owned by a certain person and it has a certain area, in mostly it is registered in hectares, then you can give the person who owns that parcel a proof, can be written, it can be written proof, but in most cases it is something that is printed. Normally in the current generation and in the current new technology, you print this proof, and they are printed. They are the new titles that we have that says this parcel owned by a certain person, then the area of that parcel, and it also includes the sheet number or the map that correlates with this title. If you go to the registry, you want to see how the parcel looks like on the map, then the person will just refer the title. The title has a sheet number, then that sheet number is checked and you will be able to see that parcel on that map. Having been given this proof, then it takes us to the socio-economic development, because for us to develop, for us to grow as a society, and for us to make any new development, we need a transaction or a form of exchange. With this proof now, you can transfer it from one person to another. Also, because I own this parcel and I have proof for it, so does not pose a much big of a challenge for me to either, like, I start to wonder, will I carry the entire parcel and take it to the market? But with the title now, the person I'm selling to this land, I'll prove to them that I own this land and provide a documentation or proof, and that is the title, which now is even admissible to court because it has followed the procedure and statutes put in place for the registration of that title. Since the law allows for you to do the registration of this title, it gives you a means to transfer, because the natural law states that if you can hold on to something, then you can allocate it an equal, or you can associate it with an equal value. Since you have given this land, you can hold to the land, then you are giving it a certain value, and you can exchange it now with another person. The law does not specifically tell you that your land is a certain, can be bought for a certain amount. No, we do it naturally in the market, and with that, the law does not directly create value for your land, but it creates the means for you to create the value, because it helps you to hold on the land and show the proof that I own that land. And with that, transaction and social development and social economic growth is made possible. With different social developments, then we get different types of curiosity, and we get different forms of how do I want to praise myself. And with that, I might want a different development from another person, and the other person might want a different type of development than I want. Maybe I want to build a mansionette, but another person wants to build a cinema hall. How do we match so that we don't have chaos building together and it becomes a squash of a mixture of elements? How do we do it? The law also puts in place formalities that restrict us from doing mixing either industries and residentials, apartments. It also restricts us from mixing industry and agriculture. And these are all set into place by the regulations we have, such as zoning regulations and zoning laws. They specify that a certain area is set aside, or that region, whoever owns land in that region, can only do industrial development. And again, it specifies that in another occasion, someone who owns parcels in that land, they can only do agriculture. Then it also specifies that persons who own land in a certain region, they can do commercial development. And with that, you have formalized development. You don't have a mixture of of all the elements together. And that's a means to control urban development, and it is done through by the law, done therefore so that we can have a formalized form of engagement and form of development. That's all for today. I would love to hear what you have to say about this, how you think law creates value for your land, and also how you think maybe it is a more restriction to what you would like to do development on your land. Thank you. See you on the next one.